There is a powerful effort underway to weaponize ancient history as a modern legal title deed. In his book, Israel on Trial, federal judge Roy Altman attempts to bring courtroom rigor to the Middle East. He claims that Palestine never existed because ancient archaeological evidence proves the land belonged to the Jewish people thousands of years ago. But if we are going to treat this conflict like a court case, we have to look at how the law is actually being applied. When you peel back the rhetoric, you realize Altman is not acting as an impartial judge. He is handling a highly selective defense brief. First, the argument relies on a classic strawman. No serious historian denies that ancient Israel and Judea existed thousands of years ago, or that Jewish people have deep historic roots in the Levant. But acknowledging ancient history does not erase modern title deeds. History is a continuous timeline of changing borders and names. The region was designated Syria Palestina by the Romans, and for centuries under the Ottomans and the British, Palestine was the recognized geographic home of the people living there, both Arab and Jewish. To claim a modern nation cannot exist because an ancient one was there first is a profound logical error. More importantly, look at how Altman handles international law. He cleverly focuses on a hyper-technical letter of the law while completely perverting its spirit. It is the ultimate display of semantic maneuvering. We have lived through 3/4 of a century of this exact style of legal distortion in America, where clever lawyers twist the literal text of a statute to justify actions that defy common sense, ethics, and basic human morality. It is the exact kind of lawyering that leaves this country in dire need of tort reform. Altman hunts for obscure pre-1967 loopholes to claim the land was essentially unowned under international statehood criteria. He focuses on abstract real estate technicalities while completely ignoring the living, breathing human beings native to that soil. He completely sidesteps the cornerstone of modern international law, Article 2, Paragraph 4 of the UN Charter, which absolutely prohibits acquiring territory through military force. The entire purpose of the post-World War II legal order, from the UN Charter to the Geneva Conventions, was established to protect human beings from being conquered, displaced, and rendered stateless. Even the modern genetic data he appeals to backfires. Peer-reviewed DNA studies show that Palestinian Arabs share that exact same deep Levantine and Canaanite ancestry. They did not arrive from nowhere. They are the indigenous population that stayed on the soil for 15 consecutive centuries, while empires, languages, and religions converted around them. God's covenant was fulfilled and universalized through Jesus. It was never a secular, genetic real estate contract. And in a court of law, a historical grievance from 2,000 years ago does not justify the systematic eviction of a third party today. By prioritizing statehood loopholes over human lives, Altman uses the letter of the law to violate its humanitarian spirit. Followers of Christ would be wise to remember that the Pharisees focused on the letter of the law, but Jesus focused on the spirit of the law.